out and get them and obtain the result they would like. Because the problem with a divorce is it's a pure definition of limbo. And most people don't like being in limbo. And the attorneys who...
Limbo meaning there's an awful lot of uncertainty.
There's a lot of uncertainty and nothing's happening. I mean, it's status quo, and people are unhappy, and it's just going to have to stay that way until the divorce is finalized. So I believe it makes sense is to work hard for them and try to move it along. So it's a divorce that lasts, if there's no children, between 60 and 120 days, and if there's children, anywhere from 5 months to a year. Now, not typically, but by statute, if you have children, you can't get divorced sooner than 6 months. But if both parties are on the same page and it's in the best interest of the children, if all the issues are resolved, if you go to court on a joint basis, joint motion,
okay,
most judges will grant a divorce after 4.5 months to 5 months.
They'll waive the statutory requirement that it'll be 180 days?
That's correct, the 6 months. They'll waive the 6 months.
Now, many times in a divorce, at least on TV, you hear the word dower. Mm-hmm. Does dower apply in Michigan?
Well, I don't believe. I mean, I don't look at it as a concept in how I handle divorce.
Okay.
You have the marital estate.
Okay.
And if you have a long-term marriage, typically you'll ask a client, where did you develop your net worth? I mean, did the both of you develop your net worth from the time you married forward? Well, then that's pretty simple. Mm-hmm. That's the marital estate. Now, sometimes in a short-term marriage, they will have, they've brought assets to the marriage.
Okay.
And then, of course, you have marriages, second and third marriages, where people will have prenuptial agreements. So they'll protect certain assets from a divorce, and then maybe the assets that they've obtained jointly, those will be subject to the divorce proceedings.
Okay.
So it varies.
And Michigan has different laws than other states, too.
It does.
So are we, for lack of a better term, a no-fault state?
Yeah, we're no fault. In Michigan, as far as obtaining the divorce, it's no fault. But fault can come into play when you're talking about property settlement and when you're talking about spousal support.
Okay. So if the offending spouse has done something inappropriate, if you will, that could affect the amount that they pay or the amount that they receive.
As far as property settlement and spousal support, that's correct.
Okay, now, you've been doing this a long time, and I don't mean to put you on the spot, and if you think I am, tell me, but are a lot of these cases tried?
No.
Okay.
Most of the cases are resolved at what's called mediation.
Okay.
What will happen is somewhere around the 4.5 month mark, the court will come in and ask you for a settlement. We'll ask for a settlement conference, and we'll ask, where are there issues between the parties? And if there are still issues between the parties at that point in time, they'll typically want you to go to mediate the case in front of another lawyer, and usually the case will get resolved at that point in time.
Tell the folks out there what you mean by mediate.
Well, here's what happens. The case starts. Someone comes in, I file a complaint for them, and typically where they're living in the county in which they're living. The spouse will answer it, and then there'll be some discovery going back and forth. What I mean by discovery is to try to find out, what the assets are, what are the views as far as child custody and parenting time, and whether spousal support is going to be an issue. And the attorneys will work back and forth to try to get these issues resolved.
So to narrow the scope of what's actually being litigated.
Yeah, if litigated. And of course, during the process, the circuit court, the friend of the court, will have them come in to do a child support calculation, and if there are custody issues between the parents, if they haven't resolved the custody of the children, then they'll send them for a friend of the court investigation with respect to custody.
So the court still controls many aspects if it's not resolved by the parties.
Right. Well, the court will push the parties to resolve it. So somewhere around the 4.5 month mark, or if a divorce is more intricate, at a period outside that, down the road, they'll suggest that the case be mediated.
Okay, and you prepare written summaries, both sides, as to what your position is on whether it's the issue of child support, the issue of visitation of the children, whether the children can move out of state if there's a move necessary for
property settlement, spousal support. And what I do is I make sure we write a written brief, and then I will attach a schedule which shows the marital assets and debts, and then how we propose that they be split.
Okay.
And you meet with the mediator. Mediation sometimes can last a couple hours or a couple days. And typically that mediator, that independent mediator, pushes the parties together, and they do it. They use one of the tactics they use is that if you're going to keep arguing about it, you're going to keep spending a lot of money. And of course, that mediator has a good understanding of how the judge rules because they have a lot of experience. We use experienced mediators, and they can talk to each party and say, look, on that issue you're going to lose. On that issue you're going to win. Here's what the judge is going to do with it. And as a result, that forces cases to settle.
In other words, if somebody comes in with an unrealistic expectation that they're going to have 100% visitation or they're going to have control of the children at all times, the mediator can say, the judge is not going to do that.
That isn't going to happen, that's right.
Okay.
But I think it's smart for attorneys to do that even beforehand.
To tell them, look, this is not, you're not getting everything you want. The pie is going to be split.
Sure. When a client comes to me, I try not to, prey on the emotions. I take the emotion out of it with my numbers background and say, look, this is what I think the property settlement's going to be. This is what I think the spousal support's going to be. And what have you discussed with each other about custody and parenting time as far as the children? And I have a pretty good sense, based on my experience, where we're going to end up, and I think most lawyers do. So as lawyers, Judge Bucci, who passed away several years ago, he always used to say the lawyers should be part of the solution, not the problem. And I sincerely believe that. So that's the way I look at it.
What does the court do if the parents just say, look, I'm not going to talk about this person getting Monday, Wednesday, Friday, and me getting Tuesday, Thursday, Saturday? I mean, what does the court do? Is that where they send them off to mediation and say?
If there's a custody issue or a parenting time issue, the court can have the friend of the court do an investigation and they'll make a recommendation.
Okay.
So you do have to talk about it eventually. You can't hold out to the end. That just isn't going to work.
Now, at what age typically do the children's interests get expressed by the children to the court?
Well, they will talk to young children. They'll talk to children that are 6, 7 years old, 8, 9, 10 years old. They'll talk to them and interview them and see what their thoughts are, if there's a tug of war over the children. And then, of course, as the children get older, if there's disputes, post-divorce, or people are divorced where their children are a little bit older, 13, 14, then the children will have a say. And if there is a dispute between the parents, the children will have a say. They'll be listened to by the friend of the court.
Will they be listened to by the judge in making his ruling or her ruling?
Yes, they will. Either the friend of the court will tell the judge what the children said, or sometimes the judge will interview the children in chambers. Okay. So they will have a say, they will have an impact.
All right, so we've talked about the beginning of the case, the history of the case, the filing of the case, the defense of the case, the investigation of the case. Ultimately, how does the divorce case, get resolved?
Well, if a majority of the time at mediation, if it's done at the courthouse, when the parties agree, they will then put it on the record and they will spell out the settlement, all the terms of the settlement, custody, property, spousal support, if any other issues. They'll spell them out, and then they'll take the proofs. They will testify as to the correctness of the complaint and that the allegations were true at the time made and true now. And then the judge will give the attorneys 21 days to have a written judgment entered with the court.
Okay, detailing what was just placed on the record.
That's correct.
Is there a way, and then we're going to go on, I know that there's some do's and don'ts that you highly recommend as it pertains to the children, which I find to be extremely important, so we're going to move on to that. We've got about 10 more minutes.
Okay.
Is there a particular way that in the event that when the divorce is over, can you come back in and try and change some things?
Well, property settlement, no. Absent fraud.
Okay.
You can't come in and change that. Issues regarding the children, you can always come in and seek, file a motion and ask the judge to request the judge that there's been a change in circumstances and there should be a change in child support or custody or parenting time.
Or visitation and parenting time.
That's correct.
The do's and don'ts for your children to make it through a divorce without being scarred too badly. You've written about, you've talked about, you've been involved with seminars and things of this nature. Give us some of your input on that.
Well, what I did is I kept a list of what people would do, indirectly or directly that had a negative impact on their children. And then I put it in order, and about 3 or 4 years ago it was published in the Bar Journal. There was 113 items, do's and don'ts. I've just